Hi, good evening. Welcome to Introduction to Condominiums. This is a webinar that's really geared towards, new condo board directors, new owners, anyone that's new to condos and wants to know a bit more about condominiums. It's intended to raise awareness, help answer that question. How do you know what you don't know? It is introductory. This is our beginner course. There's many other courses CCI offers, which we'll be getting into a little bit as well, so you're aware of them. My name is Richard Elia. I'm a condominium lawyer. I'm joined tonight by two other very good, very to me fabulous speakers. Bilal Mirza is a lawyer with the condo law team at Simpson Weigel. He chairs CCI Golden Horseshoes Education Committee. He's a fabulous resource. And Michelle Joy, who's director of condominium management at the Hamilton office of Wilson Blanchard Management. She also volunteers at CCI GHC's Finance Committee and on the Conference Committee. Both Michelle and Bilal have become go-to presenters for the chapter. They're always willing and wanting to help out. The course tonight, as with many of the sessions that CCI puts on, is without cost. CCI is not for profit. We're not publicly funded, so we do rely on sponsors to help us through. So tonight's session is being sponsored by Smith Valeria Law, Elia Associates, Condominium Lawyers, and Pretium Consulting Engineers. And again, tonight's only one of the sessions offered without costs. Some of you might have seen our Condo Talk series, which is a lunch and learn type format. We've tackled cash flow during COVID, construction projects during COVID, riding the insurance wave. That was a two-part series on managing insurance risk, understanding the power, duties, and responsibilities of directors and homeowners, discussing the expanded jurisdiction of the CAT. We've got another one coming up on the 16th called Money, That's What We Want, about how do you set up a file to allow for cost recovery? How do you best do that? It should be very good. We also do, some of you might have been at our first session of Lawyers, Guns, and Money, which was last January 21, case law update, and there's more sessions like that. So I like to start with what I call the condo paradox. Condos have been marketed for years as carefree turnkey living, and on this belief, they're sort of becoming the retirement communities of tomorrow. But we're not told that when the condominium living involves the need for someone to step up and put themselves in service of others, that this is the condo director. We're not told about the various personalities that each condo has. You could have two condominiums with they look the same. They've got almost the same condo docs, very different personalities though. We're not told about the politics that come to play. And the need to stay involved in them. And lastly, and this one's coming up more and more often in my practice at least, we're not told what happens if no one actually wants to be a director. Again, carefree turnkey living, you didn't know. As directors, I'm sure many of you are directors, you're putting yourself in service of others, you're in service of your community. And going back to that original question, how do you know what you don't know? Education, or the lack of it, has been identified as a major cause of conflict in condominiums. It was one of the major drivers for the CAO to be developed as an educational body. We're seeing mandatory education for directors, mandatory education and licensing of managers. We don't yet have mandatory education of owners. We pushed for that. We could always hope. We don't, but there's always CCI to fall back on. Going forward, I do want to stress that it's important to recognize that every condo is unique. Well, I made the comment just a few moments ago about having a condo that looks the same and has, virtually the same documents. It's almost impossible to actually find two condos which are that similar. There's always subtle differences that do make a difference. So in that regard, you've always got to look at matters as it pertains to your own condominium, seek the advice you need for your condominium. I'm just going to start off with a little question of what is a condominium. And the very simple answer is it's a method of ownership, of land ownership in common with others, communal land ownership, be residential, commercial, mixed use. And, many of you probably are already aware that condos made up of units, perhaps, not always, common elements, always. Exclusive use could be there, assets, shared facilities. Units can be almost anything: residential, parking, storage, lock units, garage units, hallway units, sign units, telecommunication units, you name it. It can be out there. Dock, for if you have a condo on the water, there are dock units. Common elements are defined as everything else but the units. Exclusive use common elements are a subset of common element, and it's where the common elements are set aside for the exclusive use of one or more owners. And again, it could be parking spaces, lockers, patios, decks, docks, balconies, etc. You notice I say parking spaces, not parking units. Very, very important distinction. Condos have assets. Of course they do. These are your bank accounts, for example, your investments. Could also be, you might own a superintendent suite or guest suites. You might own some extra parking units. Your visitor parking might be unitized. It might be equipment, furniture, etc. And a condo can own, acquire, encumber, dispose of real property. Lastly, you might be involved in shared facilities. Sometimes these are unitized, sometimes they're not. It really depends on your condominium. It could be a rec center, could be a shared driveway, it could be shared visitor parking, etc. So I often like to ask a question at this point, which is, are you my type? So I'm going to ask Katya, who's our tech person in the background, to run a poll at this point. And the poll is, which of the following does not relate to a freehold condominium? I want to tackle this term of freehold because it gets, to me, it gets misused so often. So which of the following does not relate to freehold? Units include front and rear yards. Unit includes roof and foundation. Units include driveways. Unit sits on leased land. And then which of the following best describes a freehold? And it's the same thing, except last number 4 sits on land owned by all the owners in a condo corp. So take a few moments and give me your thoughts on those questions. I'm going to jump to the next slide and give you a hint, maybe. Katya, do we have the results?
I'm going to give it another moment. We only have about 19 people so far.
Okay, so 70% says which of the following does not relate to freehold condominiums? Unit sits on leased land. That's right. And which of the following best describes? 83% says land unit sits on land owned by all the units in a condominium. And yeah, that's it. What freehold means is you own the land. And basically every condominium is freehold unless it's leasehold. So a leasehold is where you sit on leased land. If you're a condominium that was built before 2001, you're standard. You're a freehold standard condo. That's all there was. May 5, 2001 was the cutoff. Post 2001, you could be standard. You can be phased, vacant land, common element. It's usually in the name of the condo how that works out. I'll just go through some pictures. So a standard condo, you've got, let me bring up my highlighter. Laser pointers are nice. So here's the condominium, all in orange. We have townhouse units, 4 blocks of townhouse units with a central driveway. So the condo is the whole thing split up into units, and the rest is common element. standard condominium or any condo before 2001. Then we move on to what a phased condo. Now, a phased condo, I don't know if you saw that little transition there. A phased condo turns into a standard. It's something that's possible post 2001, where half of it might be set up initially, and then the developer finishes the second half, and it all gets rolled into one condominium. There is no shared facilities agreement in place. So you end up with the same thing as that standard condominium. One thing to remember is for carrying claims comes, or the time starts to run when each half is completed. So you don't get a new timeline on phase one simply because phase two gets rolled into it. A common element condominium. I said at the beginning, not all condos have got units. This is one of them. A common element condominium only has common elements. So in this case, you'd have a private road and a park, and that would be the condominium. Now you want to say, where are the units? Well, the units are, they're not units in this case. You've got what's called parcels of tied land, or pottles, you'll hear them referred to, where they're separately owned, but they're tied to the condominium. When you buy your home here, you buy a share of the common interest in the condominium. There's no carrying coverage for the condo. There's no residential part of this condominium. A vacant land condo, similar to the standard condo, except nothing's built yet on the units. So you've got the common elements, and then you've got units, and typically your declaration will describe the process for building. It might be that the developer might build you your dream home, or you might be able to have your own builder. Each setup is unique. And then the last one, the one that's not a freehold condo, is a leasehold condo, which, as I said, it sits on leased land. And this was a creative way to allow property owners to deal with their land. The property owners that we're talking about usually have restrictive covenants on title that prevent the sale. So think university lands or church lands, where they can't sell the land, but they can certainly allow it to be developed and leased. So these are typically 40 to 99-year leases. I haven't come across a lot of these in practices yet. What surprises me, and it's a little bit frustrating, it's an overall frustration with practice, is most people I talk to who live in leasehold condominiums don't realize it. They don't realize they sit on leased property. So the value, I see the value going down the road as you get closer and closer to the end of the lease, the value dropping off. We'll have to see how that works out in the long term. I'm just going to stop. That was the brief intro. I'm going to now just turn this over to Bilal to carry on, unless there's some questions at this point. Bilal, were there any questions? I didn't.
No, I just saw one comment, but no questions.
Okay.
Sorry.
The comment that was submitted was just, Richard, you made a comment earlier about struggling to get directors, and there's just a suggestion to establish a nominating committee to seek out people and provide insight on what's involved.
Absolutely,
helps take the fear away a little bit.
There's many strategies. Some boards actually try to bring up people to just sit at the board level, take part in board decisions without actually having a binding vote. It's called creating legacy, or legacy planning, I guess. And there's a question: can you bequeath a leasehold condo in your will? Accepting that I am not an estate lawyer, I don't see why not. Whatever interest you still have in a leasehold condo, I don't see why you can't pass that on the same way you could any other property holdings.
Yeah, there shouldn't be any issue with doing that, like dealing with any other real estate. Richard, I'll take it on from here then.
Fabulous.
Thank you. sharing my screen here. Thanks for the introduction, Richard. So I'm Bilal Mirza. I'm a lawyer at Simpson Weigel, and I'll be talking today about three different areas covering off directors' responsibilities and governance issues under the Condominium Act. I will talk about the condominium documents that you should be familiar with. And lastly, I'll be speaking to owners' meetings and just going through some of the requirements and what are the different owners meetings that one comes across in a condominium. So for director responsibilities and governance in particular, what you should be aware of as a director is that the overarching scheme of legislation which governs this area is the Condominium Act, as Richard also mentioned. It's by and large a consumer protection legislation, and the idea is to protect the home buyer community with respect to minimum thresholds and standards that are set out in the Condominium Act that the developer, the builder have to conform to, and certain disclosures that have to be given to new home buyers and to of condominiums, and also unit owners as they live at within condominium communities, what disclosures have to be given to the unit owners from time to time periodically. And there's been more and more disclosure in the past couple of years with the amendments that have come in requiring periodic information circulars, etc., to be provided to unit owners. So that's something to be generally aware of with respect to directors' responsibilities. Let me go on to my next slide here. Section 27 and Section 32 in the Condominium Act generally govern the director's responsibilities and governance. Section 27 in particular sets out that the condominium shall be governed by a board of directors. So it sets out the requirement that it's the board which manages the corporation. And then furthermore, Section 32 sets out how does the board actually go about doing that. It says that the board shall not transact any business of the corporation except in a meeting of directors at which quorum of the board is present. That's very important to understand that it is at an actual meeting, a physical meeting, or now if the condominiums constituent documents permit it, through a virtual meeting where you conduct the business of the condominium corporation. And it's important that the decisions and the matters that are discussed at the board meeting are properly minuted and properly recorded in the records. It's also often seen that board members may decide matters by way of, let's say, exchange of email, etc., and which is fine, but it's important that those email consensus that may have been obtained by way of circulating emails are then recorded properly in the subsequent board meeting, so they're given that proper formality that the legislation requires. So that's important to note. How are meetings called? Board meetings. You have to look at the act itself, which is section 35 of the act, and you always want to look at the bylaws of the corporation, in particular bylaw number 1, which is usually the organizational bylaw of the corporation, which sets out requirements for how do you actually hold meetings. So the requirement generally is that there must be a notice of the meeting given to all the directors. It can be by various means set out in the legislation: prepaid mail, courier, fax, etc., or email. The notice must be given at least 10 days prior to the date of the meeting, unless the bylaws state otherwise. And the notice of the board of directors meeting should specify the time and the place of the meeting, and should generally set out a description of the matters to be discussed and dealt with at the meeting. Some other things to be mindful of: every condominium corporation is required to have at least a president and a secretary. So you would be appointing amongst the directors those two offices. There can be more, of course. Other items to be aware of are the qualification requirements for directors for a condominium corporation. The legislation sets out certain basic requirements. You can supplement and add more restrictions and requirements within your bylaws. The basic requirements in the legislation are that the director should be at least 18 years of age, should not be an undischarged bankrupt, capable of managing property. So those are some of the things that you have to abide by. And then, like I said, you might have more restrictions within your bylaws. Some of the more recent amendments that came by way of the amendment to the Condominium Act include a requirement that all new directors of condominium corporations complete an online course offered by the CAO, the Condominium Authority of Ontario, within 6 months of their election or appointment. So that's something to be aware of. You have to complete that, and they do some rigorous follow up on that as well, from what I've noticed. It's valid for 7 years. And there's also a requirement for directors once they're being considered for appointment, and you might have seen this at meetings if you've been in an owners meeting where there's been a director election being contested. There's certain disclosures that directors also now have to make. They have to disclose in writing in a prescribed form whether they're directly or indirectly party to any legal proceedings in relation to the condominium, convicted of any offense under the Condominium Act, directly or indirectly involved in any contract so as to avoid any conflict of interest, and that their common expenses, condo fees, are not in arrears for more than 60 days. Usually, directors can continue to take and retain their office for 3-year terms, but of course, it may be differently set out in your bylaws. Section 17 sets out certain other requirements for a director. In particular, what is a director required to do? The objects of the corporation are to manage the property and the assets on behalf of the owners. So that's the basic obligation on each director. The corporation has a duty to control, manage, and administer the common elements. There's a duty to take all reasonable steps to ensure that the owners and occupiers comply with the Act, declaration, bylaws, and rules. So these are some of the basic requirements, obligations that are entrusted on the directors, and they have to discharge these obligations as they continue to act as the directors for the condominium corporation. Uh, the directors are also required to enforce the Condominium Act, the declaration, bylaws and rules. We'll talk about these documents in a bit more detail in a little while. But the owners and the board have the right to insist that these governing documents are complied with. And there's various tools at their disposal for them to ensure that they can actually go about ensuring compliance with the Act and these condominium documents. Section 37 sets out the standard of care that's required for condominium directors. Firstly, it requires that each director or an officer of a corporation will exercise the powers and duties of his or her office honestly and in good faith. So that's very important. Of course, there are different ways to interpret honesty and good faith, but essentially you have to ensure that there is no malice. There's an honest belief in the actions one takes and is pursuing, and there's absence of any malintent or an intention to defraud or to seek unconscionable advantage for oneself. Those are some of the things that you have to ensure. That's a fiduciary obligation, as it is when you're acting as a director in a, let's say, a business corporation. So you have to ensure that you're acting in the best interest of the corporation at all times, and you're acting honestly and in good faith. You're also required to exercise the care, diligence, and skill that a reasonably prudent person would exercise in a comparable circumstance. So that is the objective standard, the reasonable man standard that you have to judge the standard of care that a director has to discharge while they're a director in a condominium corporation. So keep those standards of care in mind as to the threshold, as I said, that applies to that to directors. Of course, there's lots of case law and there's lots of commentary which goes into this in a lot more detail, but that's how the legislation sets out these requirements. Another thing to note, and this is very important, Section 37, sub 3A and B of the Condo Act says that a director can rely on the opinion of a lawyer, an engineer, auditor, and other individuals whose profession or experience lends themselves to credence to their opinion. And then if a director relies upon an expert's opinion or advice, they cannot be held liable. So whenever you're in doubt or whenever there's something which is outside the skill set that the board possesses, it's also a good idea to engage outside professionals and to then, if you're relying upon that professional advice, you as a director can absolve yourself of liability because the Condominium Act provides you a blanket immunity in that case because you're relying upon an outside professional who has that uh, expertise. So that's section 37 sub 3, which provides that immunity, so to speak. Some other tips for good governance for directors, it's good to be proactive. Good communication goes a long way between the board and with the owners in general. There are many ways that you can garner and improve communication. As I said, relying on professionals where appropriate. And it's also very important for the directors to familiarize themselves as much as possible with their obligations, the act, legislation, and in particular their own condo documents, and make sure that they're up to date and they're, performing the function that they're supposed to be performing, and are in keeping with the times. Because we often come across, and I'm sure Richard does as well, condos from many decades ago who've and they haven't updated their documents, and there's many things that are left to be desired when you're looking at these documents, and it's quite a task to overhaul such documents. It's a good idea to keep them periodically updated. So that's the documentation, the obligations of directors. Second part of my presentation is on the condominium documents. In particular, there are at the top of this hierarchy, it's the Condominium Act. That's a legislation that gives birth to this whole concept of condominium living in Ontario. And then below it is the declaration, then bylaws, rules, and policies. What's important to note in this, the list that you see on your screen, is that the higher up the document or the item is on this list, uh, the more difficult it is to, of course, amend that item. Of course, legislation, you need parliamentary intervention, but for other things, you need a higher level of unit owner participation or consent to amend those documents, the higher up it is on that list. And each document in this list has to conform with the documents above it in the list as well. So that's also important to note that there can't be any inconsistency. And if there is any inconsistency, the one that's higher up on this list prevails. This is something to be mindful of. This takes me to a poll that we have on condominium documents, and just to test the knowledge of the audience on uh, the condominium documents. So you have two questions here. The first one is that um, the directors are looking to put into place a new restriction for pets. The board is considering that no unit owner should have more than 2 pets per unit, and that all dogs within the condominium should be on a leash while they're in the common elements. I mean, when somebody's walking their dog in the common elements. Which documents should the board consider to introduce and include these restrictions? The options are the condominium plan, the declaration, the bylaw, the rules, or the policies. So you can pick one of those options or documents as you deem fit as to which document should the condo board consider if they're looking to put in these new restrictions for pets, and and how pets or unit owners use their common elements in relation to their pets. So you can answer that one. And the second question is about a condominium board that is considering to amend the proportionate share in which unit owners pay their condo fees. So in many condos, let's say they're all equal. Let's say if it might be that all condos pay an equal amount of fees, but in many it's a different, it's a formula, it's a proportion that's set out in a schedule in a document. So you're looking to determine which document the condo should consider amending in order to change how much unit owners pay in terms of condo fees in relation to each other. So you can again pick the 5 options: condo plan, declaration, condo bylaws, condo rules, and policies. Um,
Bilal, if I could just pipe in when, as people fill out the poll,
uh-huh.
going back to your point about updating documents and the higher document trumping the lower one. It's often used as an excuse not to update. For example, when the act changed in 2001 and in 2017, everyone's declaration of bylaws were deemed to be amended. But it adds a lot of confusion, and confusion leads to conflict in a condo. It's what you don't want.
Mhm.
Quorum requirement used to be 33%, and a lot of condo docs still have that.
Right.
You might see, I've seen bylaws calling for the annual budget to be voted on and approved.
Mhm.
It's all stuff that you don't want to see. You want to see things evolve. Other things might just be might just be unclear. Like one that seemed to come up a lot this past winter. Sidewalks shall be cleared by the owner and the condo. Well, who is it? Who takes responsibility?
Right. Right.
You know,
No, I see. I agree with you, Richard. And
Yeah.
I think it's a good idea. Like, even if the underlying legislation's change, that you still ensure that the documents reflect the law. So you should be taking those steps to ensure that the documents are in keeping with the current legislation. Always a good idea. I see that we have our results back here. So for the first one, for the pet restriction, I see the overwhelming majority has chosen rules, and that is the correct answer. But you will often see such restrictions now more and more in the declaration as well. So it's not uncommon to see pet restrictions in the declaration. And bylaws is also a place where you can put pet restrictions, because it makes it a little more difficult for it to be changed in the future, and for it to be, for it becomes a little more secure when you put something in a bylaw. And we'll talk about that in a bit. But by and large, mostly you see pet restrictions and rules, and that is the correct answer as well. With respect to the um, changes to the proportional contribution interest and ownership interest, the answer is declaration. That is correct, because there's a schedule that you attach, schedule D that you attach to the declaration, which is a list of all the unit owners and the associated percentage ownership that each unit has in the common interest of the condominium, and then how much they proportionally pay. If you want to change how much a unit owner is paying in relation to another unit owner, you have to change the declaration. That's the only way you can do that. So that is the correct answer there. So it seems like our audience is fairly knowledgeable with respect to condominium documents, which is good. I'll go on to discussing the first set of documents, which is the declaration and the description. The description, as it's called in the Condominium Act, is often also called the condominium plan. I'll talk about this first. It's a survey. It's usually a big fold-out survey, which the surveyor prepares before the condominium is actually registered. It shows, you saw some, Richard shared some good reference condo plans and of different kinds of condominiums in his presentation. That's what a condo plan is. And also, like I said, interchangeably, the term description is also used. It shows all the units, shows all the common elements, shows any exclusive use common elements for condos. And it's basically the document which will show you exactly where your unit is in relation to everything else. A very important document to review. Um, the declaration, on the other hand, is the document which is registered contemporaneously with this condo plan, and it's basically the document which creates the condo. It's much like the articles of incorporation of a business corporation. It creates the underlying condominium. It will set out basic features of the condominium, what the nature of the condominium is. If it is it a standard condominium, a common elements, vacant or leasehold condominium, like Richard was speaking to in his section. It's much like a constitution in that case, because it will set out the nature and the basic features of the condominium. Each condominium has one. No condominium can exist without one. So you will always invariably have a condominium. The Act requires certain basic requirements for a condominium. You have to set out, as we saw in that poll, it's mandatory that the declaration set out the percentage unit ownership rights and the percentage proportionate contributions that a unit makes towards condo fees. It must also set out any exclusive use common elements that may exist in the condo, must also exist, and set out the boundaries of the units. It may have things like a statement of the condominium common element expenses as to what different expenses constitute the common expenses, the various expenses that the condo incurs. It can include things like restrictions on leasing and sales. Short-term rentals is a popular one these days. You can put that in declaration and then ensure that there's no short-term rentals. Restrictions on occupation or use of units as to what different uses a unit can have. You can just restrict that in the declaration, and then it's then, like I said, it's not set in stone because you can still change it, but you need a much higher percentage of unit owners to consent to ever change it in the future. So it becomes a lot more difficult for it to be changed in the future. You would invariably also see within the declaration the respective maintenance and repair obligations between the condominium corporation and the unit owners. So who's repairing and maintaining what on the condo? Like if you want to know who's supposed to be mowing the backyard, who's supposed to be plowing the driveways, all of those things you will be set out in much detail in the declaration, the respective rights and obligations for maintenance and repair. Uh, it must be consistent with the Condominium Act. You also have to ensure that the, this document, um, in fact, you have to ensure that the document is registered. So, like, as I said before, so it's in any time you make any amendments or looking to make any amendments to the declaration, it also has to be similarly registered. So it's a document that's readily available because it's registered on title. If you ever want to amend it, you need at least 80% or 90% of the unit owners to consent. For many, vast majority of things, it is 80%, but for a few specified things in the Act, you might need even 90% of the owners to consent at a meeting held for that purpose in order to amend the declaration. So that's how you would go about amending a declaration. Some of the other things you might find in a declaration are pet prohibitions, as we discussed, satellite dish uses, parkings, restrictions, student noise, use of amenities, etc. Bylaws. Bylaws are governed by Section 56 of the Act. Some of the examples that we often come across, as I mentioned before, is the general governing or operational bylaw. You might come across a standard unit bylaw, a borrowing bylaw, occupancy standard bylaws are common, assessment bylaws, mediation and arbitration bylaws, etc. Um, it, Basically, if a declaration sets out what is a condo, the bylaw would normally try and deal with how does a condo go about doing its business. So it will set out in the bylaws basic organizational matters and some of the other things that we discussed. The Act itself also gives certain examples of various things that you should be dealing with by way of a bylaw. For example, a new easement that if a condominium is considering um, to either give to grant or to be subject to, or to remove an existing easement, for example. These are just some of the examples for things for which you need a bylaw. The threshold to either create a new bylaw or to amend or repeal an existing bylaw is 50% of the unit owners. So you need 50, a majority. So 50, you need at least 50% of the owners to consent to the bylaw. So that's a bare majority is what you need. Um, um, it must be consistent with the Act and regulation, the Act and the declaration. And it is also, much like the declaration, it is registered on title. So there's a formal process of how you would pass a bylaw. It goes through a meeting. Like, you need to have an owners meeting for that purpose, where all the unit owners get together and vote. And if you have the bare majority, 50+1, then you get the bylaw passed. And then, as a final step, in order for the bylaw to be applicable, you have to then register it on title, and that's when the bylaw becomes enforceable. So that's something to keep in mind as well, because that step is an important part of the whole process. And you, of course, you need to engage someone who can then register that for you. Rules. Rules are governed by Section 58 of the Act. The purpose under the Act is to promote the safety, security, or welfare of the owners and the property, and to prevent unreasonable interference of the use of the property. So anything that encompasses those areas are usually the subject matter of rules. Things like, how do you go about, living at a condo, or how do people live at a condo? There are things that you normally find in rules, like noise levels. What time do you use certain amenities, like a party room, etc. Like, you might have rules for usage of these things. So those are all things that you'd normally find in rules. These documents are, the process is that the board creates the rules. It's required to give a notice to all the unit owners. The unit owners have a time frame within which they can object to it. They can requisition a meeting to formally object to it. And then if there's a requisitioned meeting for that purpose, then the unit owners have a vote. And if the majority of the unit owners vote to challenge, who've challenged the rule, if they, the overwhelming, or in this case, the 50% or more of the unit owners vote in favor of overturning the rule, then it lapses and does not get into effect. But if the board sends out the notice for the rule and nobody objects, nobody requisitions a meeting, on the 30th day after the rule's been notified to all unit owners, it becomes applicable. It is not registered on title, so that it is easier that way as well. It's not something that you have to go about registering on title to the condominium and the units. There's also an additional requirement within the law that the rules must be reasonable. So there's a lot of commentary around this as well. Does not apply to declaration. So in the declaration, you can put in things which might be patently unreasonable. Like, you can put a restriction in there about nobody living in the condominium who's taller than 6 feet. So you can put a restriction like that in the declaration, but things like that won't fly in the rules. So there's an obligation on the condominium and the board to ensure that the rules are reasonable. So you have to have that in mind as well when you're drafting rules and passing rules as board of directors. So do keep that in mind. Policies. Um, Policies are generally various processes that the board may have to deal with certain things which are more process oriented in their working. So things like collection of fees, things like how do you go about booking a party room, etc. So they're basically just guidelines or guidances for the unit owners, and um, they're not as legally enforceable as some of the other documents, but it's just basically documenting a process. So it's easier for people to replicate and follow it as they go along, and very easy to change, of course, because it's just a policy that the board has created for their own convenience. Some of the other documents that you should be aware of are shared facilities agreements. Richard also alluded to this before. These are agreements between the condominium and adjoining land owners. So it can be an agreement between two adjoining condos. There might be certain features on that on one or both condominiums that are shared between those condominiums. So this agreement essentially would set out what those shared features are. It can be amenities, can be servicing, a road. So it will also then set out what the respective rights and obligations are, who pays for how much to maintain it, There might also be something like a shared facilities committee, which governs and oversees these shared facilities. So that's something you might come across as well as another document. Easements, as I mentioned, is also something you may come across when you're looking at a condominium in terms of its documents. So that's the second section. I can take a little break here if there are any questions that we need to take up before I proceed.
Yeah, Bilal, there are some questions, and I didn't answer them because my typing isn't working tonight.
Sure.
What was the number for passing a rule? If you could just explain that again.
Oh, sorry. Okay. So to pass a rule, you essentially just need the board to write up the rule and send out a notice to all unit owners. So if nobody objects, you don't really need a magic number to reach for it to become effective. On the 30th day, when the notice is sent out to all unit owners, it becomes effective. But if the unit owners take a issue with the rule, they can requisition a meeting, and at that meeting, if more than 50% of the unit owners vote in favor of doing away with that rule, then it does not become effective. So in that case, you need the majority of the owners at a meeting where basically the subject is discussing the rules. You need the majority to vote in favor of the rule, if that happens.
Just to clarify, the quorum requirement is different between rules and bylaws in this sense. For rules, it's the quorum stays at 25%, and it's the majority of those in attendance voting. Whereas for bylaws, you need a majority of the whole building voting in favor. Can a condo corporation limit or cap the number of units purchased for lease or rental?
I don't see any reason why it can't. Like
it would have to be in the declaration if it did.
Yes.
Because it would be seen as being a limit on the alienation of property, somewhat unreasonable. So it would have to be in the declaration. We tried. British Columbia actually has the ability to do this in a bylaw, and there was a push for it before the 2001 amendments. There was a push for this, and we couldn't get it through. So I've never seen it in a deck, but that's where it would have to be. What you do see are limits on the duration of the lease, like restrictions on short-term rentals or a minimum lease term. That could be in a rule even. You know.
Yes. And you're right. If there were a restriction as to how many you could lease out, then you would have to. The declaration would be a proper place for it to go in, and I don't see any reason why you couldn't restrict the ability to lease out in the declaration.
Okay, I understand the CAO Director Code of Ethics trumps a condo corporation. Do both have to be signed by directors? I wasn't aware of that. I don't think it's correct. Have you heard anything about that, Bilal?
I have not. Michelle, do you know about the CEO Code of Ethics?
I do not know. The only aside from corporation specific code of ethics, the only other code of ethics we typically use with directors is the CCI code of ethics.
Yeah, but even that's voluntary. The CAO does not trump the Condominium Act. I want to stress that. And I'm going to give out my own personal beef. This is not necessarily the beef of CCI, but I'm finding CAOs putting out legal advice that they should not be doing. I don't know what they're saying about the code of ethics. The requirement in the act about being a director is you have to be over the age of 18, not an undischarged bankrupt, and mentally capable of managing property. That's it. Oh, and you've got to do the disclosure form. We're seeing more and more condos adopting code of ethics, but those are usually appended to a bylaw and read in. The bylaw itself adds it as a qualification to be a director. And there's a case from about, 5, 6, 7 years back that supports the fact that you can do this, but it's got to be there. Otherwise, it's not a qualification. And does it have to be signed? If the bylaw has it as a requirement to be a director, then yeah. What are the requirements for how proposed rules are communicated with owners?
The requirements to communicate the proposed rules to
Yeah,
owners. So
how do you do it?
that is a legal requirement. So you have to send out a formal notice. So it goes out to all unit owners at the address of service that they might have provided, and it's a requirement that the board send out that the rules the rules that they have drafted to all unit owners, and it's a requirement. Unless that's been done and the requisite period 30 days has passed, the rules will not come into effect.
And the just to add to that, more and more condos are encouraging owners to give the consent, the written consent for electronic communication. So if you've got that, you can do it via email, and that works. And then you've got to have there's got to be a covering document basically saying when the board proposes that they come into effect, and giving owners the knowledge that they can requisition the meeting, and as well, I believe, Bilal, correct me if I'm wrong, a copy of Section 46 of the Act,
It has
which
to
is
be
the
reproduced.
requisition. Yeah.
Yes. So you have to give the actual provision. That's a 1 or 1.5 pager that you have to photocopy from the Condo Act, and you have to attach it to the notice that goes out to unit owners, so they know their rights. So they know that they have in fact the right to challenge and question this rule. And it also then of course sets out how do they go about doing that. They have to take and requisition a meeting, and at that meeting they can formally take a vote for the majority of the people present at that meeting to have that rule done away with.
Okay. The next one, and you on the slide you've got up, or an advanced session. This is there's a lot more of this in the advanced session. Is who decides what is reasonable? How does a board enforce a rule? What tools do we have?
Yeah, so I would say that you have to, of course, use your own best judgment. And the things that we talked about before is that you have to ensure that you're making the decisions in good faith, and being using the services of outside professionals where you're not sure yourself with respect to reasonability. So that it can be something which might be a human rights issue. It might be something which might be outside what your skill set is with respect to determining is this reasonable or not. Always best to seek the guidance of a subject matter expert on that issue, to determine if that is something which, if you're unsure about it, or it's always a good idea to get some professional advice. But if you're reviewing the draft rule, and if you're not sure about its reasonability, then there's a discussion discourse amongst the board. It's a good idea to have that discussion and have somebody give you some sort of formal advice on that.
Just to add, as far as tools to enforce, there's been mandatory mediation now for the last 20 years for rule disputes between the condo and an owner. With tenant, it's you can go to court, and now we've got the expanded cat jurisdiction, so more and more is going before the cat. An example of what's not reasonable, and I think there's an old case, Habdavni and somebody in Toronto, where the board it seemed like they just didn't like this unit owner and the fact that he had 2 dogs. They had a 1-dog limit that they ever enforced, or 1 pet, and then they didn't enforce against anybody, but everybody else had cats, and they modified the rule to go after Mr. Habdavni's dogs and leave out all the other cats, and that rule was found to be unreasonable and challenged.
Yeah. And Richard, I think what's very important about that case, and generally the point that you're making, is that the board has to ensure that they keep an even hand between how they treat unit owners. So you can't give special treatment to certain unit owners at the expense of others. Yeah. It's very important that you treat all unit owners equally and keep an even hand in how unit owners are dealt with. And that's part of the criteria that the judge will have if it's ever before a judge to determine reasonability of any particular rule. Are you singling out someone because they're in a just the facts of the case seem that way?
Yeah. I'm going to let you carry on because there's still a lot to get through.
Will do. So just enforcement of documents, just the last slide here. Ensure that, like I mentioned before, just ensure that you have proactive communication. If there are rules in place or other items in place, requirements in your documents, ensure that they're communicated proactively to your unit owners, and also the whole process. The more involved the unit owners are in let's say new rules or new changes to condominium documents, for example, the less friction there is. And then when things break down, like Richard mentioned, the act specifies there's a whole chapter which deals with remedies and mediation, arbitration. How do you go about dealing with those issues? And now, of course, CAT has the condominium tribunal in Ontario has a much larger scope in terms of what it can also determine. So that's something to take note of. I'll go on to my next and last section here, unit owner meetings. So unit owner meetings, it's in an interesting way of looking at it is that it's the fourth level of government. You have unit owners are the voting public. They vote in and elect your board of directors. They're the elected government for however long their term is. The property management and other people who are assisting are the bureaucracy, and then assisting with the affairs of the corporation, and then you have outside consultants. But the unit owners are really the driving force behind how the condominium is run, because they're electing the board. Uh, Three different kinds of meetings. I'll go through them individually. The most common and the ones that you have to come across every year are the annual general meetings. They're mandatory. The Condo Act requires them. Section 45 sub 2 says that you have to have your first AGM within 3 months of the condo being registered, and then every year subsequently within 6 months of your year end date, fiscal year end date, you need to have an annual general meeting. Some of the things that you come across at an AGM are that the auditor may present the financial report of the previous fiscal period. You may appoint the auditor for the upcoming fiscal period. You will have a discussion about the budget for the upcoming year. You will also, if there are open vacancies, you might have an election for the directors of the corporation. Usually the board may presents a report of significant matters that have arisen and have they've dealt with in the past year. So that's something you also come across in a AGM, and there might be other business matters. Section 45 sub 3 requires that the owners can raise any matter for discussion at an AGM, but in order for there to be a vote on that particular topic, that item must have been shown in the agenda for the meeting. So that's something to keep in mind. You can of course bring up topics from the floor and raise topics from the floor, but in order for any material action to be taken on that item, it must have been pre-disclosed in the agenda as one of the items that would be discussed at the AGM. Um, Requisition meetings, you also see on your screen there, is basically a meeting that's requisitioned by the unit owners. You need at least 15% of the unit owners to sign off on a formal requisition. It's a prescribed form, must be in writing, must be signed by all the requisitionists. It must set out the nature of the business that the requisitionists intend to discuss at this meeting and be the subject of the meeting. Must be delivered personally or by registered mail to the president and secretary of the board. Once the board receives this requisition in the proper form, then the board must respond within 10 days of receiving the notice. It can either call and hold the meeting as a first option, or it may decide not to respond. And if that's the case, then the meeting is deemed to be called in that case. So if they take no action, then the meeting is deemed to be held. Or the board may respond and say that there were issues or discrepancies in the requisition, and it can then give an opportunity for the requisitionists to fix those whatever the defect was in their requisition. Um, Much like in AGM, there you might be following the same kind of protocols at the AGM. You can only at a requisition meeting you can only have a vote on matters that are properly matters that owners can vote on. So things like um, rules, like if somebody's not happy with the rules and they want to repeal rules, that can be a topic for a requisition meeting. You can vote on removing directors. If somebody's not happy with the slate of directors, that's an item which can be subject to a vote at a requisitioned meeting. So anything that can be, which the act allows the unit owners to vote on can be the subject of a requisitioned meeting as well. So that's something to keep a note, make a note of. And then information meetings are things like town hall meetings, meetings where basically the board is trying to get some information out to unit owners. It might be that there's some new project going to that's being contemplated by the board, and they want to make sure that the unit owners are on board, or they want to get some information out to unit owners. It's just an opportunity for the unit owners to get together with the board and have an open dialogue about whatever this thing may be. Like I said, might be a construction project, might be changes to the condominiums documents, anything of that nature, significant nature. It's a good idea to have these meetings, and the act permits the board to call such a meeting under section 45 sub 4. You have to comply with all the other requirements and protocols that you would have when you're calling, when the board's calling an AGM. So you would send out forms in much the same manner. You have to also ensure that you're using all the mandatory forms. They're prescribed forms to use to requisition meetings, to send out notices of meetings, preliminary notices. You have to make sure you're using all the correct forms. They're all on the website for. You can find them on the CEO website as well. Unit owner meetings expectations. So some of the things you want to watch out for are open communication between unit owners and the board. Engage with the unit owners, and of course have mutual respect back and forth at these meetings, because you'd want that to have a smooth flow to these owners meetings. Uh, the timelines are very important. So you have to make sure that for having your AGM, if you're planning to do an AGM, you have to think about it at least 2 months in advance in terms of planning, because there's about a 37-day window within which you have to give out all the notices. So you have to start planning ahead of time. So the first notice that goes out is the preliminary notice, which is the notice which sets out basically that a formal notice of meeting will come out at a later date, and this preliminary notice must be sent out at least 20 days in advance of the notice of meeting. So you have to, let's say if you've selected a certain date on which you want to do the AGM, you will want to count the days back to when the notice of meeting should go out, and then count the further days back to make sure you send out the preliminary notice at the correct date. So the preliminary notice goes out at least 20 days in advance of the notice of meeting. And then the notice of meeting itself is required to go out at least 15 days prior to the actual meeting date. And then there are other requirements in the act and prescribed forms as to what you have to set out in both notices. As I said, they're prescribed forms, so you just have to fill them out, but you have to make sure they're done properly. So that's the uh, two notices. And then you can also, of course, use proxies. You have to ensure that you're using the mandatory prescribed form, though, if you're looking to use proxies. Um, at these meetings, there are various things that you should be aware of, in terms of conduct and various matters with respect to ensure that you have a smooth and successful meeting. Make sure that you have the notice and agenda items clear with clear details set out in front of you. That you have make sure you're setting up the notices properly. Have a general understanding of the rules of order. Make arrangements for answering any questions. Have all the professionals attending if you expect specific questions on, let's say, a particular project. So some of the things that you should be aware of. Michelle, do you have any tips generally about how to run a successful owners meeting? Some of the things that you come across, especially these days with the virtual meetings, etc.
Yeah, I mean, being organized and prepared is always the key to success. I think virtual meetings have actually made it a little bit easier because often most of the information is now at your fingertips. You haven't forgotten to bring a sign-in sheet or a minutes template, or, you know, the most recent copy of your information certificates, because most of that's accessible on a server online now. So it makes it a lot easier. But one tip that I think is always really great is, as a board and as a corporation, in prepping for your AGM, put out the call for questions in advance. It's such a useful tool because the board actually has time to prepare detailed and responsive answers to those questions, as opposed to being on the spot at the AGM. So that's always a great tip I like to give my boards, is put out a call for questions in advance of the meeting so that we can be prepared to really give a great answer when we're physically at the meeting.
That's a great idea, Michelle. Thank you. Um,
That call for questions works so well. You know, when you get to new business or other discussion, the property manager could just stand up and say, "This is a question. This is the answer. This is a question. This is the answer." It completely diffuses tension in the room.
mhm.
Well, I just wanted to bring up the with information meetings. Sometimes there's a meeting just has to be called very quickly. You can't deal with the fast timelines.
Right.
You know, with not the fast timelines, with the timelines set out in the act, the 37-day window that's up on the screen.
Mhm.
And then you've got the cat that says if you call it a meeting, you have to keep minutes. You want to just comment on, say a bit more on that?
Certainly, Richard. So that's the requirement to have a mandated meeting under the Condominium Act, that you send out the proper notices. But if the intent is for it to be an informal meeting, and if the idea is that for the purpose being that you want to disseminate some information at the meeting, so in that instance, I imagine, Richard, that you can have the meeting without having done the proper preliminary notices, but then of course then the requisite requirements for recording the minutes, etc., would not apply.
Well, it's kind of the cat comes out with some interesting rulings sometimes. And there's one that if you call it, they're basically saying if you call it a meeting, you must have minutes.
Yeah.
But if you must have minutes, you're transacting business. If you're transacting business, you're supposed to keep to this 37-day window. But
Right.
if you have something urgent, you can't.
Yeah.
So what I would suggest is
something
call
else.
it a wine and cheese, call it a whatever you want,
So
but
don't call it a meeting.
Don't use the word meeting. And if you need it, the reason being, as directors, you sometimes are between a rock and a hard place. You want to just get direction from the owners. It's likely non-binding direction. So call it I don't know what you want to call it, town hall, wine and cheese, whatever, to discuss something, and you can take a non-binding vote even just for direction of the board.
Yeah, and I agree with you, Richard, especially for things which are not for meetings where you don't expect them to be very formal and you're just looking to get some dialogue going. It makes sense to do it that way, and then and it goes to the point that we are discussing before about having more open communication as well.
So Bilal and Michelle, have either of you two dealt with lost minutes? Either the recording is lost or the minute taker's notes are lost.
I mean, the recordings are so new that we're just kind of getting into that territory. But lost minutes, it's been encountered before. It's not fun.
Bilal, do you want to add anything?
No, I haven't come across that situation myself, to be honest.
I just like to add minutes. When we read minutes, there's so much more than what they have to be. Minutes are just they evidence the business transacted at the meeting in their simplest form. That's all it is. And the only mandatory business at an AGM is the election of directors and the appointment of the auditor. That's all it is, as far as mandatory business. So if you've lost the recording or lost the notes, the minute taker's notes, somebody's got to have written down who got elected or who got appointed auditor. And then you just make the records, have it ratified at the next meeting. It shouldn't be that difficult. Having a record of who said what during new business, not necessary.
That's not. I agree with you, Richard, because you're looking to just ensure that the basic requirements that the Act has, you cover that off, and that would qualify as valid minutes. It doesn't have to be word for word.
And as far as directors attending, or I'm sure Michelle, you probably do the same thing. Keep notes. When I'm prepping for a meeting, all my notes are in red. When I'm at the meeting, I'm writing in blue, so I know what's changing. But I typically keep a very accurate record of who's being elected, who got appointed auditor, what are novel issues raised at the meeting, etc. I want to know.
I also think just what we try and instill with our directors, hire a professional minute taker. I know, again, this comes down to cost with a lot of smaller corporations, but hire yourself a professional minute taker for meetings of this importance.
There is a condo talk recorded. If you go on the CCI Golden Horseshoe website, there's a condo talk on minutes. I forget what it's called, but it's on minutes.
Got a minute.
Got a minute. There you go. And then last question before we go on to Michelle. What about mailing time? Is that considered to be, say, 15 or 20 days plus mailing time or including mailing time? Bilal, maybe you can back up that slide to the
Sure.
And explain the at least.
Yeah, so that's you want to make sure that you give yourself one day on each side. So that's why you see that it says 37 days as opposed to 35. You also want to err on the side of caution and give yourself that extra day. So when you mail it out, like you want to make sure that it's you have given yourself the 1 day buffer on each end for the notice periods.
Yeah, in our office, we actually go 40 days. We do date you place it in the mail and date that you would receive it in the mail on top of the 15-day timeline. So
I like the conservative approach. There's a whole body of case law that says the words "at least" mean you don't count the day of mailing or the day of the event. That's where the add 2 days comes from.
Yep.
And then about 3-4 years back, we had the legislation act that came out that reinterpreted the words "at least" to mean you only need to add 1 day. That's why this chart, the at least 20 becomes 21, and the at least 15 becomes 16, and that's where the 37 days comes from. But I like the conservative approach Michelle put out.
39 or 40 days. I think that's a better approach to take. If you have the time, definitely do that. You don't want to be run afoul of that 1 day and having that whole, if somebody question the entire process just because it's the 1 day, definitely add the 1 day on either side just to be safe.
Okay, Michelle. Hello, if you can stop sharing.
I will, sorry.
Thank you.
Thank you.
just give me 1 second to get mine up now. All right. So I'm going to be talking about property management this evening, and then I'm also going to talk about a little bit about the money side of things, which is incorporated into property management. So there are several different options to consider for your corporation for property management services, and I'm going to go over each option, what it is, and the pros and cons or the benefits and drawbacks of each option. So the first option is self-management. So self-management refers to when the board of directors carries out the day-to-day management duties for the corporation. A working board is definitely more work than a governing board, and we're going to get into kind of governance and how the relationship between management and board works in that aspect. So being a self-managed corporation, if you're a director at that board, you're going to be doing a lot more work than some of the other management options, but it can still be appropriate in some circumstances. Self-management is usually an option we see in much smaller condos. Again, the cost for management services just may not be feasible. I know I was working with a 6-unit condominium the other day. So, I mean, 6 units does not going to have a very large budget to cover all the costs that they may want to cover. So some of the benefits of self-managed corporations. So first is a sense of accomplishment. Because of the hands-on factor of supervising projects, handling the day-to-day aspects of the property that a director may be taking care of in the self-managed aspect. Directors and owners realize and appreciate that it's not the condominium corporation that should be doing things, covering expenses, all of that. They are the condominium corporation. The owners are the collective, form the condominium corporation. It can provide a little bit more of a personal touch versus a business touch approach that professional property management firms have. It may result in a higher vested interest amongst all the owners, not just directors, because again, the owners are who are acting as directors have a lot of hands-on experience in the day-to-day operations, and again, may have cost savings. Like I mentioned, self-managed, there's typically no cost associated with the management services of self-managed, so you're saving that. However, the one drawback from that may be that you don't have the buying power that a larger firm would have, as they typically develop relationships in the industry. So then the other drawbacks include you may not have the necessary level of expertise. So licensed property managers take courses and write exams in the various areas of expertise in order to get a license. That's not required for self-managed. Potentially higher use of consultants, again, because you don't have that educational background, possibly. You may need to use lawyers and engineers a little more often to get the answers and the guidance that you need. Another big one I find in my experience in dealing with corporations that have been self-managed in the past is the level of comfort when dealing with enforcement issues. So it can be difficult for a self-managed board to deal with enforcement problems because you don't want to get into a confrontation with your neighbor. And in the same respect, owners may feel uncomfortable discussing personal issues with their units with directors because you all live together in the community. So that can be a drawback as well, not having kind of an independent liaison to handle those situations. Continuity of records. So because you don't have a professional firm doing record keeping for you, as people leave, come and go from the board, or sell their unit, leave the property, there may be a lack of continuity of record keeping. Depends what type of system you have in place for your corporation. Directors will have a substantial additional responsibility and liability, donating considerable time and effort to fulfill the duties required to run your corporation. And you may also have a challenge in purchasing adequate directors and officers insurance. And then the other key thing I want to touch on here is that kind of all the drawbacks, the pros and cons that I'm talking about right now, is a self-managed situation where the director is not receiving remuneration, is not being paid for their services. If the self-managed director is being paid, they will need to be licensed under the Condominium Act. So if they're receiving any type of compensation as a result of the services they're providing the corporation, they would need to obtain a license through the CMRAO, just like any other manager in the industry. So the next is direct employee. So direct employee is when the site manager is hired directly by the corporation and the board of directors. So you're not hiring a management firm, you're hiring Michelle Joy directly as an employee of your condominium corporation. So the big benefits here are control of the manager's salary, as opposed to if they worked for a management firm, the firm would set their salary and that would be built into your monthly or annual fees. And you have total control of the management function. So you're not going off of what your management agreement says. You can direct the manager to work like the corporation would like to operate. You can customize the various aspects of your management services. There are quite a few drawbacks to this option as well. The cost of training. So you're going to have to onboard and train these individuals that you're directly hiring. Replacement for illness. So if your manager goes on vacation or they are sick for a couple days or even a longer term leave of absence, the condo corporation is going to be responsible for trying to find someone to replace that individual, as opposed to through a management firm. They would have someone be able to fill in or cover the vacation time. They would make arrangements for you. The employer-employee responsibilities can be costly. So you're going to be responsible for, the government, CPP, EI, all of those costs. There's no senior person to turn to when things go wrong. So, and again, in a management firm, there's usually a large leadership team. If you're not happy with the services your manager is providing, you can talk to their direct supervisor or a regional manager. In this case, dealing with the manager is directly the responsibility of the corporation and the board of directors. You would also likely need to hire a separate company to do bookkeeping or accounting services for you. So that's going to be an additional cost to what you're paying your manager. And again, insurance may be available in this case, but it might be at a higher premium. So the next option is company contractor. So this is where you're entering into an agreement or a contract with a property management firm. So this is probably the most common type of option that, I mean, at least I encounter, but I also work for a property management firm, but I would say this is the most popular option. So a property management firm is hired by the condominium corporation to provide a property manager and related services. So the benefits to the full management option is your time commitment as a volunteer board of director is much more reasonable. So as opposed to the self-managed option, or even when you have a direct hire, it's a lot more commitment from the board. When you have a property manager and a firm that supports them, your responsibilities as a board and the time that you need to commit to that should be lessened, because a lot of those responsibilities are deferred onto the property manager. The board can focus on governance rather than management. So they can make the decisions and have the manager act to implement all of those decisions. You can get a potential cost savings as a result of volume purchasing. So again, a management firm builds relationships with other clients in the industry so that you might have purchasing power, or even something as simple as your banking fees. A property management firm typically has an agreement with one banking institution, which may give you lower annual fees on your accounts because they have so many accounts with that institution. Senior support for site managers. So like I said in the last one, a property management firm typically has a leadership team, an executive team. So if you're not happy with your manager, or if you find that your manager is struggling, you can reach out to their supervisor, the regional director, VP, president, whoever, and they can help support that manager to be more successful, or make a change if you really don't feel it's ever going to work out. Support for illness and absence. So if your manager is going to be gone for a period of time, they can do vacation coverage, or if they go on a longer leave of absence, they will have someone able to go in as a replacement to cover for that person without the board having to search them out. Established chain of communication. So this goes back to the drawback of the self-managed option. The property manager becomes the central point of communication between the owners, the board, contractors. They become the main liaison. And that makes it a lot easier with the flow of communication. When you go into a property management contract, you typically get a full service package. So you're getting not only management services, but administration. So, help with all of your AGM packages, the certificate requirements, your annual returns with the CAO, and then obviously your full financial package as well. So monthly financial statements, collection of fees, paying your vendors, all of that. Improved continuity. So if a board member leaves, or even if your manager changes, the property management firm continues to maintain the records the same way. So you don't have to worry about a board member running off with a lot of your critical information. And errors and omissions insurance is provided by the management company because the manager is a direct employee of them as opposed to a direct employee of the corporation. A couple of drawbacks for this option. Obligated to follow property management firm overall processes. So when you enter into agreement, it's going to lay out all the different services that you get. You're going to get a standard financial package. You're going to get a standard monthly report. There's going to be limitations to the services included in your agreement. So that's a bit of a drawback. You can't customize the services you're getting necessarily. You're obligated to use the property management firm banking institution. Like I said, they typically go with one institution for all their clients, so there's not really a choice in that. You can't necessarily establish the same employer-employee relationship that you could with a direct hire because final decisions on staffing are not made by the board of directors. They're typically made by leadership or executive staff at the firm. So lastly is the hybrid option. We're seeing a little bit more of this now. Just again, it all comes down to the needs of your corporation and what type of corporation you have. So this is self-management. So the board is running the day-to-day operations, but there's some level of professional management involved. So we typically call this like a financial and consulting type package. So you're going to maybe get full financial bookkeeping services. They're going to get monthly statements, handle all the payables and the receivables, but you're not going to have your property manager dedicated to the day-to-day management of your site. You will have someone assigned who's available for consultation when needed, or, you know, if you have a difficult situation arise, they can help out. And this is becoming more popular, I find, in smaller condominiums, as boards realize they do need some help and guidance along the way. I find it's also very popular for common element condominiums because there's not as much to manage with a condominium that is a common element. So it's popular in that kind of style as well. So just kind of an overview of the relationship between board of directors and management. So the board kind of sets the vision for the corporation, and the manager should be the one that helps implement it and deliver that vision. You know, you want to set, and I talk about this a lot with corporations that I work with that are newer. And it actually not always necessarily newer. Sometimes it can be if a new board comes in, but the board really sets the vision of what you want your community to be. And I think that should be in consultation with your owners. But I mean, are you a high-end condominium? Do you want to be the most luxurious condominium in your neighborhood? Do you want to be a family-oriented condominium? Or, you know, we see condominiums that really focus on being green and energy efficient. So you can kind of set that vision and then work with your management staff to help implement that vision. And they can help guide you to do what you need to do to achieve that. So just kind of highlight some best practices of governance. And we talked about how, depending on what management services you have, the board may be able to focus a little bit more on governance as opposed to day-to-day management. So governing your condominium corporation, whether self-managed or direct hire or a property management firm, should always be a team effort between the site manager and the board. And this isn't always the case. We do have some tensions, you know, we encounter tensions, and sometimes it's just personalities, but sometimes it feels very much like the board feels that the property manager is the enemy, and it can be vice versa as well sometimes. And we really need to work together as a team to achieve the overall goals of the corporations. So the challenge here is to identify which member of the team should be taking charge on which issue. And again, that definitely is where a lot of conflict stems from, is the manager's not doing enough, or the board is maybe micromanaging a little bit, or they feel that they're taking on too much. So how does the board determine when they should get involved and when they should let the manager handle it? And I'm going to go over a few helpful tips for that. First and foremost, we're going to determine if the concern is really a board issue or something better handled by the manager. For example, the board handles issues that affect the whole condominium corporation, and the manager handles issues that affect individuals. The board handles issues that dictate what the condominium corporation will do. In other words, policies. So you're going to give direction on the policy, and the manager is going to take that information and implement the policy amongst the corporation. Board handles issues that are dictated by bylaws or as requested by the manager. Unfortunately, many situations are not clear when it comes to responsibilities, and it's no wonder that conflicts exist in the manager and board relationship. It's important to understand that directors do not take action as individuals. They must act as a team. Acting as a team, the board sets policies and goals for the manager to implement. So this is another thing I stress with, especially new boards or new board members. Decisions and actions should only be taken first and foremost at duly constituted board meetings with majority of the board. So one director cannot give the manager direction. I try and kind of steer directors away from getting too engaged in a conversation with an owner. And again, there's a fine line on this, because obviously you want to engage in your community, but you know, if I walk up to Richard in the hallway and say, "Hey Richard, I'm going to replace my flooring next weekend. Any problem with that?" And I'm like, "Yeah, no problem." That's not how we should be acting. So always has to be a team effort with majority of the board making decisions. Good communication is key, so that when the responsibilities get confused, the board of directors and managers can resolve those problems. So just going to highlight kind of some of the different different areas when it comes to setting policies, approving budgets, hiring the manager, how that flow works. So the board, for example, would set the policy. We want to update the policy on the elevator booking. These are the different things we want to add to it. Or perhaps you have no elevator booking policy at all. Your rules say elevator must be booked for a move, but there's no process in place to handle that. So board of directors would discuss the policy that they want to implement, give that information to the manager. The manager would draft the policy and draft the notice of the communication to go out to the owners so that they are aware of the new policy in place. Budgets. So the board of directors approves the budget and typically the manager prepares it. So as a manager, I'm going to prepare a draft budget well in advance of the year end for the board of directors to review, but ultimately that decision falls to the board. So I'll prepare a draft and then we go through it and the board makes the final decision on approving the fee increase for the year. Hiring of staff. So the board of directors hires the manager and then the management hires the staff. So typically the most common staff member that we see is a superintendent. So as a manager, we're going to post the application or post the job posting for the superintendent. We're going to field the resumes, we're going to review the resumes, screen them, interview, and then bring any valuable candidates to the board. I think that should have final approval. So that's kind of just how the relationships work between one another. One other, kind of talking about communication, the manager ends up being the main point of communication for day-to-day issues, notices to residents, letters, and then the manager would take any issues to the board that need to be discussed. But ultimately the board's responsible to set a communication plan and then the manager follows it.
Michelle, before you move on to planning,
Yeah.
there was a question that came up,
Sure.
and I just want to see how you answer it because your bias might come out.
Okay.
How long would you recommend the maximum amount of years a single manager should be with a condo?
The maximum amount of years the single manager should be with the condo. I mean, my opinion would be as long as the relationship continues to be good. I don't think that there's a cap on how long, a term in which a manager expires. I think, to me, in my perspective, the problem is more so a manager is not with a condominium long enough. I think the longer the better, in my opinion. And that's just my feedback from working with clients in the industry is actually, I think frequent turnover is more detrimental than someone who's with a condo for 20 years. I mean, to me, that's a blessing. They know the history and everything about your site.
Yeah. If I could I'll just add to that because I share your view, by the way, and I'm not in management. But there's sort of, I think there's three parts to it. There's the management contracts, which generally are similar. Then you've got the back office support, and then you've got the site manager. It all goes together, and it all has to work together. The contract protects you if something goes wrong, but the contract doesn't go into the day-to-day details that makes the relationship work. The back office provides the skill set, but then the site manager's got to implement that. So ultimately you need, if someone's coming to me, they'll ask, well, who can you recommend? And I can list off management companies that we feel very comfortable with, but ultimately it's got to be a skill set match and a personality match. If you have that, I don't see the point in getting rid of it. It's like trading in your car because the next model years come out.
Yeah, no, I 100% agree. And we work with managers that have been on sites for 10, 15, 20 years. It's very uncommon now that I personally feel, but yeah, if you have a great manager that works well with your corporation, keep them. That's my suggestion, or try and keep them as much as possible. It's a very, the industry has changed a lot over the last few years. Managers move around a lot more than I think they did in the past. All right, planning, financial, and other responsibilities. So first thing we're going to talk about here is an annual plan, dates and timing. So all condominiums run on an annual calendar. It's going to be your fiscal year typically. And everybody's fiscal year can be different. Doesn't necessarily be January to December. It's based on the date of registration for your corporation. So that annual plan or the annual calendar consists of an annual budget, an annual report to owners, yearly contract renewals, maintenance, etc. Like I said, the fiscal year is usually related to the date of the original registration. Best practice for any board of directors is to develop an annual plan that sets out the expectations contained in the budget and pinpoints when the work will be done. So these are an excellent tool for corporations, and I definitely recommend that corporations have some sort of an annual plan, and don't just create the annual plan, actually use it. I find so often we create these plans, but then we don't fall back on them. And they're great for continuity, you know, where we're talking about continuity and how that can be improved with different styles of management. And the annual plan can really help out on that as well. So the annual plan will set things like the month for the AGM, the dates for the board meetings. It'll identify renewal dates of contracts and the insurance policy, dates for routine maintenance, and dates for routine communication notices. So I think the manager should be the one to initially draft the annual plan for the board. But ultimately, it should be a collaborative, I think, piece that's put together. So kind of like the budget, the manager comes together, prepares an annual plan, and then the board should review it as a group and make sure that they feel it's accurate. And I was having a conversation with a manager actually this week about how to best use the annual plan. And what I said was, I think it should be, you know, if you have monthly board meetings, take a look at that annual plan on a monthly basis. What's happening in 60, 90, or even 30 days, you know, this time of year right now, you're looking at, you know, I know we're in the beginning of March, spring's on the horizon. So you need to be looking at your annual plan. When do you have your garage cleaning, your irrigation startup, your pool opening, your spring walk around? Let's talk to the contractor about your annual planning. So the annual plan helps kind of trigger all of that. And I think it should be reviewed on a regular basis with the board and management, so you stay on top of everything. Planning and money. So budgets, money, and banking. So it's important to understand the meaning of community living in a condominium and the differences between condominium living and living in a house before discussing budgets, cost collections, money, financial statements, checks, signing, audits, etc. Living in a house allows freedom that is not possible in a community living environment. For example, projects around the house, such as fixing the fence, the roof, the cleaning of the windows, can be delayed when money is not available. As a homeowner, you have the choice to say, can't replace the fence this year, can't afford it. Furthermore, garden maintenance, snow removal, lawn care can be done at a convenient time to you, regardless of your neighbor's opinion, or at least, you know, until the municipality becomes involved. In a condominium, it is very different. Ignoring things is not reasonable or how you can approach management of your property. Owners expect the building to be clean, orderly, and in good condition. Owners considering resale will want good curb appeal throughout the property. Others will want the fence and roof fixed, windows cleaned, attractive landscaping, because it's the environment in which they want to live. And that's the reason they've bought into a condominium, is for that community living. You know, my neighbor's grass is going to get cut every week because that's part of my fees, and that's part of, you know, the condominium's responsibility. Owners have to realize that their personal financial circumstance and expectations do not and cannot determine the condominium's costs. It is the collective circumstance and expectation of all condominium owners which determines them. Owners have to understand that not all costs will benefit owners equally, though all owners contribute to the cost. So easiest example of this is, I live on the first floor of a 10-story high-rise. It's very likely that I'm going to use the elevator, but I don't get to opt out of the percentage of my fees that contribute to elevator maintenance. So it's part of the collective living. Again, I had a conversation with an owner about this the other day, and they were upset about some of the budget increases because it didn't affect them. I said, well, you know, that's like, you know, saying everybody except for the people on the top floor of the building are exempt from paying for the roof replacement. That's just not how condominiums work. It's collective living. You may be paying for something that does not benefit you. So let's get into a little bit more detail. So let's talk about budgets, common element assessment, fees, and collections. So the budget for the corporation is set annually and does not require a vote of the owners. Another very confusing topic amongst owners, especially when you throw out a high increase. When was the meeting held to vote on this? It was not. Well, it was. It was a board meeting and you weren't invited. So owners do not need to vote on the approval of the budget. That is an authority left, or decision making left to the board of directors. You've elected the board to make those decisions on your behalf. The budget identifies all services and costs of running the corporation. So, like I said, the manager typically prepares the draft and then the board sits down and goes through all the figures, makes sure that it's accurate, and then ultimately approves it. Once the budget's approved, the board should send out a budget letter and a copy of the budget to every owner. What I typically think is a good timing for that is at the beginning of the last month of the fiscal year. That's the timing that I always aim for is, so, if the year end is March 31st, my budget's going out this week, the first week of March. So everybody knows the change in fees is coming. I will put a asterisk there and say, if you have a large fee increase incoming, communicate that in advance. Don't throw it on people at the last minute. If you know it's going to be happening, give people some warning. So a budget package that has a cover letter explaining the increase, how you can pay your fees, the collection process for late payment, a full copy of the budget. And I always think notes to the budget are really helpful as well, just to kind of explain what each category covers. In years of economic challenge, when incorporating more than a cost of living increase, it is beneficial for the board to hold a meeting after the budget has been prepared to inform owners of the cost consideration that the community faces, enable them to voice their concerns. So that kind of goes to letting people know if there's going to be a larger increase than usual. People just want to have their voice heard and let them know why and what the decision-making process was for those costs. The bylaws, so let's talk about common element assessment. So the bylaws of the corporation will set out how owners are required to pay their common element fees. The industry standard is that the owners pay by pre-authorized payment or post-dated checks. Down the road, online banking may become more available. I think the fees are still quite high at this time. So the standard is still PAP, pre-authorized payment or post-dated checks. Very rarely is cash accepted anymore, or any other type of payment. Credit cards are not industry-wide either. Payment is always due on the first of the month. That's when your common element fees are due. And an owner is required to contribute and cannot be exempt even if they have waived or abandoned their rights to the use of the common elements, or they're making a claim against the corporation, and or if the declaration bylaws or rules restrict the owner from using common elements or part of them. So you can't just say, I dispute whatever this situation is, so therefore I'm not paying you my fees that month. It's not the way it works. Can't be done that way. If an owner defaults, the corporation has the right to lien against the owner's unit for the unpaid amount, together with all interest owing and all reasonable legal expenses incurred by the corporation in connection with the collection or attempted collection of the unpaid balances. Should the owner fail to pay, the corporation has 90 days to register the lien to give the corporation priority over the mortgage. While the Act protects the condominium from non-payment by owners and the collection process will be set out in the bylaws of the corporation, the board of directors should review the process and set a clear policy. This will ensure that clear understanding in regard to interest and fee collection, notification requirements to owners before the legal process begins, and charges for collection. So that's collection of fees. Another key thing when we talk about reserve accounts is, so typically the way banking works for condominiums is that all the money comes into the operating account and then you have to transfer the portion of the fees to the reserve bank account. That should always be done promptly. I know in our firm, all of our corporations are set up for an automatic transfer. So after the fees come in on the first of the month, there's an automatic transfer from the operating to the reserve for that monthly contribution as set out in your reserve fund study. So the Act also sets out what the corporations can do with the money collected. Two sections of the Act, Section 84 and 115, cover this very important aspect. We learn from Section 84 of the Act that common surplus shall be applied against future expenses or paid into the reserve fund except on termination. shall not be distributed to the owners. Section 115 guides the corporation on handling of funds. Corporations are required to maintain one or more bank accounts in its name designated for general operation and one for the reserve. So you must have separate accounts for your operating and reserve funds. They cannot be in the same account. In general practice, condominiums usually have one bank account for operations and one for reserve. The manager will set up the accounts at a major bank located in Ontario or a trust company. Property management companies generally contract with one financial institution, as we previously discussed, which can help obtain lower charges for the client. As such, the condominium will generally utilize the institution that their management company has agreements with. And just scrolling my notes, I've already talked about that. So let's talk about check signing. The board of directors will be required to sign the bank authorization documents to set up the bank accounts and the designated signing officers for the corporation. To ensure timely utility payments, most corporations use PAP for the payment or EFT transfers. So you just have automatic banking and your bill says, this bill will be withdrawn on March 4th and the amount automatically comes out. This is really, most corporations have this set up for utilities because there can be large penalties and late fees or disconnection of service. Typically, you also have to pay on new accounts a large deposit, which will not be returned if there are any late payments in a certain period of time. As long as the management company provides financial statements that provide schedules showing these payments, the board should be comfortable in making payments in this manner, aka via PAP. When it comes to signing of checks for the corporation, there are generally three options. 2 directors sign each check, 2 authorized officers of the management company sign each check, or 1 director and 1 signing officer from the board sign a check. So each check has 2 signatures and there's 3 different options for check signing. In most cases, all directors are given signing authority with the understanding that the treasurer is the person who typically is most called upon for signature, but you want to have multiple signing authorities in the event that your treasurer is away for a period of time. You want to have someone else available who can sign that check in their absence. Option 1, which is 2 directors signing each check, is rarely used. That is the most risky. When 2 directors have access to the funds, it's more likely a chance of collusion, which could result in the loss of funds. Option 2, oh, sorry, my apologies, guys. I scrolled too far. There we go. Option 2 is most often used by townhome communities or very small common element corporations that have very few checks to sign each month and where it's a challenge to deliver the checks to the board member for signature. Option 3 is most common method. It reflects a partnership and responsibility for not only producing complete and correct payments, but timely payments as well. However, the board should understand that should clearly understand who the signing officers for the management company are to ensure they are a senior position and that the board can confirm the signatures. So option 3 is 1 management, 1 board of director. For proper financial risk management, the site manager should never be the signatory on the corporation checks as they issue payment and approval for purchase orders. So that's just a internal control. You don't want the person who's authorizing invoices and purchase orders to also be signing the checks. It's just too risky. Due to the size of major management companies, the number of checks processed each month for signature is high, and the use of electronic signatures will become more common for payments with the signing authority of the management company. So I can say, just from working in the industry, this is definitely becoming more common. More companies are moving towards an electronic platform for approving and paying their vendors. All right. Sorry, I just want to make sure I'm on the right slide here. Sorry, my apologies. Okay. Financial statements. So monthly financial statements should be prepared each month. They should be reviewed at the board meeting. The statements are usually prepared by mid-month, and they shouldn't be any later than the 20th day of the month to the board, and that's the following month. Many management companies are sending statements electronically now, or they can be found online to download through a portal. If not sent electronically, the statement will be part of the monthly manager's report, The report should include a variance report where the manager identifies notable changes to the statement, notable changes and concerns, including investment information. So your manager should be including a variance report, which highlights where you may have gone over budget or under budget. And investment information is also very important to review on a monthly basis. You want to keep an eye on anything that might be maturing and make a decision on whether you want to reinvest it or cash it out and put it back into your general bank accounts. Every board member should be receiving a copy of the statement. At a minimum, the statement should include the balance sheet, the income statement, the rear schedule, bank reconciliations for both the operating and reserve account. They often include additional schedules to support some of the receivables or payables, check detail, journal entry, listings, etc. It's beneficial that the board try and set their meeting after the date of the delivery of the statements. It's just going to give you the most accurate financial picture when you're at the meeting discussing those matters. Once a new statement is received, the previous month is redundant. So if a board meets every second month, only the most current statement needs to be reviewed. The statement is not approved by the board as it is not an audited statement and the numbers may change. Especially if an item was overlooked and did not get posted to the correct month. So if you have a statement and you notice something that needs to be reallocated, your accounting rep is likely not going to redo the statement. They are just going to correct it in the next month. All right, reserve funds. So the purpose of your reserve fund is for major repairs and replacements for the common elements and assets. So the reserve fund can only be used for capital projects. It cannot be used for day-to-day maintenance and operations. And your reserve fund study, which is a study put together by the corporation's engineer, will establish what those major repair projects are, and it will identify the common elements and assets of the corporation. The Act states a minimum amount contributed in the first year after registration cannot be less than 10% of the operating budget, and the contribution amount that the board of directors determines after the first year has to be based upon the reserve fund study. So once the board accepts a study, you must contribute at least the minimum that is set out in the study. If you contribute less than what the study calls for, then you will have a note put on your audit. And if issues arise due to lack of funding, the board could be held liable for not following the study plan, the plan that they've accepted. What I like to always point out to boards and owners about reserve fund studies, they are a budgeting tool. They are not a strict guide you must follow. So just because it says you have to replace the fences in 2021, if they are in great shape, don't do that project. Vice versa, if something is falling apart a lot faster and needs to be moved up 5 years in the study, do the work. That's why the studies are updated every 3 years so that you can account for those changes. So you do not have to follow it strictly. It is simply a budgeting tool and a guide to assist you. The Act makes it mandatory for condominiums to obtain an independent reserve fund study from a qualified engineering firm or other permitted provider. I would always recommend you go with an engineering firm that knows and specializes in condominiums. They're going to know the Act and what is required of you. The study analyzes the state of the repair of different components that make up the common elements, the remaining lifespan and project, and in today's dollars, the amount of money the corporation will need to repair or replace each component over the next 30 years. And that's my section there. Sorry, I tried to speed up a little bit because I know we're tight on time.
Right.
Any questions?
Just to add to the comment about using an engineer, which I entirely agree with. Don't shop for the engineer that gives you what I call a very slim reserve fund study, because the whole purpose is to have the money when you need it. If you go with the guy that gives you the lowest projection, there's a really good chance you won't have the money when you need it. Yeah, there are some questions, Michelle. Is it common practice or practical to provide 3 or 5 year pro forma budgets?
Not something that I have encountered in my experience.
Yeah.
Yeah.
I guess the reserve fund study is a type of budget.
Yeah, I mean,
Oh.
the reserve fund study is something that can go over several years. I think operating, it's a lot harder to do those predictions.
The reserve fund study, just so it's not a spending budget, it's a savings budget. Something to keep in mind. What's the range of cost for engineers reserve fund study?
Nowadays, I'm gonna say probably 20, on the low end, $2,500 to maybe closer to 4,000. Depends if you're going with or without site inspection and the firm. So I would budget anywhere from 2,500 to 4,000.
Does it vary on size of condo?
Yeah, I would say size of condo, like obviously if it's a common element versus a standard, that's gonna change the price as well. So
Okay. And last question, is there a contingency fund to cover unexpected expenses?
yeah, so this is a great question. So not a contingency fund per se, but you want to build up your surplus. So the industry best practice is 2 to 3 months of common expenses in your surplus, and that's going to be your contingency. So you want to make sure you're budgeting enough to build up your surplus year over year so that if an unexpected cost does arise, like a major insurance claim, you have enough to cover the cost of the deductible that you might have to pay. So 2 to 3 months of common expenses is what you want your surplus to be at for a minimum.
Okay, Michelle, thank you very much. For everyone, I just want to say thank you to Michelle. She's got an AGM tonight. It starts in about 5 minutes. So
Thank you very
she's
much,
got her own.
everybody. I'm going to go chair an AGM and I will leave it to you two for the rest of the evening.
All right, take care.
Thank you. I'm going to stop sharing my screen now.
Okay. And I'm going to carry on. Last three subjects, really insurance status certificate, other laws. Really, I'm doing these very briefly because insurance, you can go on our condo talk. We've got 2 full condo talks just on managing insurance risk. You can literally spend hours or days talking about insurance. Status certificate, another complex topic, a topic we haven't even touched in this intro course, are collections. That's level 200. And I'm just going to touch very briefly on other laws. Bilal and I are not running anywhere tonight as yet. So if you've got questions, we'll do our best to answer them. So on insurance, let's start with a poll, which is whose interests are protected in the under the condo's policy. Is it just the condo? Is it just the condo and the owner of the damaged unit? Is it just the condo, the owner of the damaged unit and the mortgagee of the damaged unit? Or is it all of those plus every other owner in the condo? And I guess every other mortgagee, I forgot to write that. There's some debate over this, over the implications of it, which I'll try to get to. Okay, Katya, do we have the answer? We have the answer. So 30% just the condominium, 57% is all the parties. And the answer is, in fact, all the parties. If any of you are into reading the Act, it's sections 99 through 106 deal with insurance. And what they say, section 99 requires the condo to take out insurance over the units, over the common elements and the units, excluding betterments and improvements, on behalf of the condo, the owners, and the mortgagees, all from time to time. If you read your insurance certificate, and you should be getting these every year, the condo should be sending them out with typically with the AGM notice. You'll see on it, name of the insured is the condo, and all unit owners and all mortgagees from time to time. They all have an interest in this coverage, and it's mandatory coverage at law, which means the condo cannot opt out of it. So I mentioned earlier that units are covered, excluding betterments and improvements. So what is a betterment and improvement? And there's debate on this. And the Act is actually very clear. Since 2001, the Act's been very clear. You determine a betterment or improvement by reference to the standard unit definition. Okay, then I'm sure some of you are now saying, well, what happens if we don't have one? And that's a problem. That's a big hole in the Act right now. For new condos post 2001, technically you must have one. The Act says, the declarant, the builder, has to either give you a standard unit schedule or a standard unit bylaw. Problem is most do it by way of schedule, and the schedule gets lost. We're trying to find one right now. Pre-2001, there was nothing. The act anticipates that you will put in place a bylaw. If you haven't done it, do it. It's important. Because right now there's conflicting case law on what the implication is, and the unit owners insurers always love to point to this case called D'Alessandro, which says if you don't have a standard unit definition, then there are deemed to be no betterments or improvements. Therefore, the condos policy covers everything. So imagine the unit just had a $500,000 renovation with gold leaf faucets and tin ceilings and African hardwood or Brazilian hardwood or whatnot. All that, according to this case, is covered. If you get that type of approach, call your lawyer, because there is conflicting, or there is an alternative case, an alternative position to take. As I also mentioned, it's full replacement cost. It's intended to make the condo whole. Why is this important? Because it's not just one unit that's been damaged, it's the community. And it's just as you imagine a unit that gets flooded out, severe flood or severe fire. It's in the interest of the next door neighbor to ensure that that unit gets restored as quickly as possible, as soon as possible, because it impacts them. Nobody likes to live next to a burnt out unit. That being said, it is subject to a reasonable deductible. And I'm going to speak more on deductible, because deductibles are a way to manage insurance risk. Now, unit owner insurance is not mandatory at law. If any of you have moved from a single family home to a condo, you might be thinking, "But I had to get insurance when I bought my home." Well, it wasn't. There's nothing in the law that says you had to do that. It's the bank that says if you want a mortgage, you must get insurance. That's what the banks would say. However, in a condo, the banks typically rely on the condo's policy. So unit owner insurance is not mandatory. That said, if you can take one thing away from this course, well, besides everything that Bilal and Michelle said, one thing away from what I've said, go back to your community and just really tell owners, make sure you have coverage. It's important. Think about it, insurance deductible coverage. If an owner is responsible for that, they can get coverage over that. And this has been making the news lately, because we're seeing deductibles going from, say $1,500, $2,500 10 years ago to $200,000 now. So not only do you have to make sure you have it, you have to make sure that it's high enough to cover what your condo's deductible is. And many of you have probably heard of periodic information certificates, PICs, which get sent out twice a year. One reason is the insurance deductible amount and whether the condo's got insurance. Really important to know. Other aspects that the unit owner coverage will be responsible for, besides the deductible, outside living expense. If you have to leave your unit while the repairs get done, that's on your cost, not the condo's cost. Betterments and improvements, personal effects, that's all on you. Make sure you have enough. The last one, there's something called assessment coverage. Now, this isn't assessment coverage for any special assessment that comes up. It's for when the condo's insurance coverage is not enough. So think about someone's a close friend of Austin Matthews, fellow lives in your condo. He invites Austin Matthews over, hottest leaf out there. He has a career-ending slip and fall injury on your condo property. Guess who's being sued? Well, you guys. Guess whose insurance probably isn't going to be enough? Yours. Well, where's the condo look for money? Well, the owners. They're the taxpayers. And you can get coverage over that type of assessment. When the condo's insurance isn't enough, your coverage can be. Can fill the gap. Very important. And unit owner insurance, because it's not typically doing the heavy lifting, dealing with the building structure, that's the condo, typically it's not all that expensive. So again, very important. Now, managing insurance risk. Why is this important? Well, again, we're reading and hearing about condos not being able to get insurance, about premiums skyrocketing, about deductibles skyrocketing, and you really want to manage this. And the Act only gives you two. There's only two tools in which to do this. One is recovery of insurance deductible, and the other is the standard unit definition. So let's start with recovery of insurance deductible. If we leave it up to the Act, we have a problem because the Act is limiting. Section 105 sub 2 says you can charge back, but you must show an act or omission. Now, what is an act or omission? Well, there's a very recent case on point. I can't remember the name of the case. But it's not really clarifying. They're saying act or omission lies somewhere between strict liability, which is it basically came from your unit, therefore we're charging you back, or it impacted you, we're charging you back, versus negligence, where we've got to be able to show that there is a duty, a breach of the duty, and resulting damage. Very high standard, very low standard. Act or omission lands somewhere in between. I don't like it because when there's a lack of clarity, we get into an argument or a fight, and then you waste money on legal costs, and then the whole point of deductible is lost. Section 105(3) though says you can put a bylaw in place to expand the circumstances for recovery. All right, what I like to do here is extend the circumstances so it hits that strict liability standard. If the source of that water is coming from the unit above you, we're going to charge that unit back the deductible. I don't care what the cause was. Don't care about the act or omission. I don't want to get into that fight because it's going to be expensive. And it's expensive vis-a-vis the deductible amount that you're trying to recover. So you want to manage that. There's a proposed change to the Act. It hasn't come out yet, which will require that strict liability standard to be in your declaration. I would really urge you, take a look at all the indemnities in your declaration. Make sure and talk to your lawyer. Make sure you've got them. Put in place a proper strict liability indemnity in your declaration now. If you do it now, it's an 80% threshold to get it through. If you wait until if and when this section comes into play, it's going to be a 90% threshold. It's going to be harder to do. Okay, the second tool we have is the standard unit definition. And there's a lot of discussion about this, about how it should be used. One discussion as insurance premiums and deductibles have gone way up, there's been more and more call for what's called a bare bones standard unit, where we basically take the unit down to its boundaries. I don't agree with this. It's got its place, no question. Typically, when a condo can't get insurance any other way, and I'm thinking student housing, a condo that basically is a student residence. But in most condos, going back to what I said at the beginning, that poll, who's benefiting, whose interests does the condo have to protect? It's the condo, it's all unit owners, it's all mortgagees. If you do a bare bones, that unit is not being put back to a usable and sellable condition. All right, therefore, some interests are being lost there. Again, there's a lot of talk about this on the Condo Talk. I'd urge you to go there. Status certificates. Most important part of due diligence when buying a condo, and probably the most underappreciated part of due diligence when you buy a condo. Title search when you buy a condo is very easy. Typically, it's very easy. Very straightforward for most condos. What's different and what's unique is the status certificate. When you buy a condo, you're buying into a going concern. It's a going business. You want to know what the finances are. You want to know if the condo is involved in litigation, about to be sued, whether the reserve fund is fully funded, whether the budget is realistic, whether there's an maybe an operating loss carrying forward. Who knows? How about the personality of the condo, the unique characteristics? Can you have pets? Is it pet friendly? What does pet friendly mean to you? Because is it one dog, two dogs, a dog and a cat, a big dog, little dog? Who knows? This is all in the status certificate. It's not a simple document to read or understand, which is probably why it's overlooked so much. It's more than just the 4 pages. The 4 pages are strictly really money. It's a prescribed form. Attached to that, you've got the declaration, the bylaws, the rules, the audit, the budget, the insurance certificate, you name it. If it's a newer condo, you'll have a lot of contracts attached to it. And it should all be read and understood. The cost for the condo, the condo can charge for these is $100 inclusive of HST, which means since this fee was pegged back around 1996 when the current act was still in bill form and there was only GST, the cost has gone down. It has not moved since then. I thought it was too low back in 1996 because there's huge liability and responsibility that comes with this. The status certificate binds the condo as at the date it's signed. It's a prescribed form. It answers set questions about the condo. If the condo gets something wrong, all right, it takes responsibility for it. If you've levied a special assessment and that's not reflected in the status certificate, then the condo is not collecting from that purchaser. All right, if you're, if you don't issue a status certificate, well, you're making a big statement there. Two statements, in fact. First statement is there are no bad things involved in your condo. There's no common expense arrears. There's no special assessment. There's no budget increases, mid-year budget increases, etc. You're also telling people if you can't get the simple document done and out, that you're frankly a poorly run condo. If I can't get a status certificate, or if I'm getting one that is not in correct form, I'm reading my client the Riot Act as far as what they might be buying into. Many times condos delegate this to property management. It's written right in the management contract. I would say do this. Very important. As a board, you want to keep in touch with it. You want to make sure that it's up to date. You want to ask management, but let management take responsibility. They can keep the $100. That's meaningless in the grand scheme of things. But it's a great way to deflect that responsibility. I mentioned it's valid at the date it's signed. If something changes after it's issued, after it's signed, there's no obligation to do anything. There's not. Anybody buying into a condo, if they're proper legal representation, they should be getting two of these. One at the beginning, when the deal is still conditional, they should be reviewing this, and then again right before closing to make sure nothing has changed. Oops, sorry about that. And that's all I'm going to talk about on status certificates. Again, a lot more in the advanced course. Other laws I'm just going to talk on briefly. We always like to think the Condo Act governs everything. Not even close. If you've got a law that touches people, it impacts condos. Human Rights Code is huge. PPEDA, which deals with the collection and use and storage of personal information. There was some debate. I think it's been settled about whether it applies to your typical residential condominium. I always said it does not apply because there's nothing commercial about that condo. And I think there's now a case that supports that. Definitely applies to property management companies because they are commercial. Occupiers Liability Act. Why do you keep getting sued for those slip and fall claims? Well, it's Occupiers Liability Act. You have a duty to ensure that people coming onto the property are reasonably safe. Occupational health and safety, workplace violence and harassment. We're doing an upcoming condo talk on this. I don't know the date, but harassment in condos is on the increase, and it's completely unacceptable. The courts have considered this a breach of Section 117, dangerous circumstance in a condo. Nobody signs up to be harassed in their workplace. Criminal Code applies, Environmental Protection Act applies, think commercial waste in a commercial condo. Mortgages Act applies, think collection of common expenses. We can go on and on and on. If it touches people, it will impact your condo. That's going to be it. Before we get to questions, I just want to give a highlight of what's coming up. Our next condo talk is coming up on the 16th. Again, it's a free session over the lunch hour. This one is money. That's what we want. And it really has to do with cost recovery tips for condominiums. All right, we get told, Bilal and I, I'm sure, get told when we write compliance letters, collect your fee from the owner. But we can't always do that. Why can't we always do that? Or Bilal talked about reasonableness in practice. Well, especially when we get to court, we want to show that we've been reasonable. Anyway, they're going to be doing that. We've got 2 litigators, and Anthony Castellinovo and Eric Savas, both litigators. Patrick Greco is moderating it. He's on the corporate side. Michelle Joy is back to bring in the practical aspect of how this will work with your condo. On the 25th, we've got Rapid Fire Legal, Patrick Greco and Stephanie Sutherland, 2 very experienced lawyers. And the beauty of this one, if you enjoy asking questions, this one is for you, because there's no format, pre-planned format to this. It really is, you've got 2 experienced lawyers who are just going to answer your questions. You might have something on the pandemic, the CAT, the tribunal, reserve fund, short-term rentals, enforcement. The agenda is yours in this session. Other future legal ones which aren't on the slides yet. If this intro session, very important. If you want to give the heads up to some of your neighbors, other directors, the next one is tentatively scheduled for June 24. We just finished up the advanced course last month. The next advanced course is scheduled tentatively to take place over 8 evenings, September 27 to October, between September 27 and October 21. There is a cost to this one. It is intensive. It is very good, and you get very good materials with it. And a couple of future condo talks that we were talking about earlier today. The reopening blues, dealing with again COVID reopening. And then, harassment, which is more than just a nuisance. I mentioned that earlier. So a couple of those dealing with it. And we're thinking about an evening session dealing with mental illness in condominiums. It is a big issue that doesn't get the attention it deserves or the guidance it deserves. There's feedback that you can give regarding tonight or any session you have. I hope you do provide it. It's very important to us on how we can improve these sessions. And on that note, let's deal with your questions before you leave. Let me turn off this sharing screen so we can do that.
Richard, I've been monitoring the Q&A box in the background, and I've responded to some of the questions that we had there. There was a good question at the end there about differences between performance audits and reserve fund studies, but no open questions there, unless there are other questions that the audience has.
There's one in the chat about standard unit bylaw question mark. So what the standard unit, it could be a bylaw or a schedule. If you're post 2001, you might have a schedule. And what it defines is the base unit that will be covered by the corporation's insurance. And again, in my view, it should put the unit back to a livable, sellable condition. It's a great way to first you're able to carve out the high cost items. For example, you might have fancy plaster ceilings, hardwood floors, and cultured marble countertops. I don't know. Typically, we're being advised by the insurance industry to take out floor coverings. Very hard to match up sometimes. But you don't have, the idea is not to go back to the unit as it was originally constructed. The way that idea came out was actually pre-2001. The Act said the standard was the unit as it stood at registration of your declaration and description. Remember, Bilal went over this when a condo was born. It was a lousy definition because nobody remembers what the standard was when you're dealing with an older condo. Then you have to think who got the model suite with all the upgrades. There'd be differing standards, and maybe somebody paid the developer a couple of $100,000 extra before registration for a bunch of extras. Then they'd have full coverage. So again, terrible standard. And if there's ambiguity, it creates cost and delay. And what we really want is to have a clear definition of what's covered, what's not. That way, the condo's insurance gets together with the owner's insurance and gets everything resolved as quickly as possible. So if you haven't got it, speak to your property manager or your lawyer, put it in place. And I think that's it.
I believe so. Yeah,
All
I
right.
think
So
that's the questions in the chat.
Bilal, thank you again for another great evening. And everyone, I hope you sign on to the upcoming sessions. Have a great evening.
Thank you.
Bye now.
Good night.